number of years ago, Professor Heavin, Heather, and I started doing some research into how lawyers, practicing lawyers, are working with their clients to resolve cases effectively, in particular in the corporate commercial area. And one of the things that we started to look at more closely was how lawyers are discussing or possibly not discussing the issue of litigation risk with their clients, and how they are together making decisions early in a litigation process. So the book that we're working on together does a couple of things. One is that it collects and presents information about the costs and impacts of litigation on people who are involved in it. And it does that through a couple of lenses. One is the financial costs associated with litigation, but the other are the other various costs and effects that being involved in court processes can have on people, which are sometimes less visible for lawyers.
We also talk about the ethical obligations that lawyers have to give good, candid advice, and we point out that although the obligations themselves are very simple and straightforward, actually implementing them is extremely difficult. And so then we provide this mechanism for describing the variety of costs that are involved, both the tangible costs of the lawyer's fees and the litigation costs, as well as these intangible costs of stress, of reduction of reputation, relationships, business opportunities, all sorts of things like that.
One of the big focuses of the book is our simple framework of litigation interest and risk assessment. I've identified that there are various ways that people can assess risk, but we do find that lawyers tend not to do so in a methodical, systematic way. And so breaking down various elements of a legal case, using our predictive judgment on smaller pieces of the litigation allows us to give better and more accurate predictions. We're really hopeful that the book can be helpful for both students, instructors in the dispute resolution realm, and also for, obviously, practitioners. I think in terms of the information that's in the book, it's quite understandable. It's written in plain language so that people can understand it. The appendices in the back provide really good templates for asking questions and making people think about how to go about structuring an interview and also then doing the risk analysis.
We have learned that there really is no book quite like this, and we are doing this book to fill a real gap. And part of it is that lawyers just are having a hard time advising their clients and are either going to trial when they shouldn't, when they have had a good offer, or sometimes they're settling cases without having thought them through or without having advised their clients. I think particularly for business clients, there's a greater focus on expecting their lawyers to provide better, more efficient, more knowledgeable advice. And so, and particularly with economic pressures. So this book is really very timely.